passing laws. So that's been my concern from the beginning. There are procedures that we need to follow when we do this. Mr. Husbands is aware of them, as am I. I'm neutral in this. Okay, I'm just advising you why I think a particular protocol should be followed or not followed. And so that was the protocol that I established for this. So we had Jennifer Lee obtain exhibit stickers from the courts so that we can have a good record. We know exactly what we're talking about by exhibit number, and in the event we get that far, and Mr. Husbands will be offering documents to you and asking you to receive them in evidence, and you're going to look at them and decide if you're going to receive them and pay any attention to them if we get that far.
Also, as you recall from having done this last summer, the whole issue becomes moot because they serve at the pleasure of the council.
That would be true if you put on the agenda. And when Mr. Allworth was done, we listed nothing.
Correct.
Okay, that's not what happened here.
That's
Nothing's
true.
listed.
Oh, sure it is. There's a whole bunch of things listed here. When Mr. Allworth was, it was just
That's correct. But
no.
ultimately,
I know it's correct. So that you didn't do the same as him. That's not the same.
so look at it this way: that this is an opportunity since we've never established a formal situation or a formal mechanism for reviewing performance of the nature of the highest level of executives within the city administration. This is what we're left with, which is why, again, I say that it was extremely prescient on the part of Brandy to put that agenda item on there, because we can include this in there, which could hopefully, perhaps, avoid these types of situations in the future. Now, that being said, still, we have these issues with which we have to work, and as our esteemed attorney has pointed out, that is why this information hasn't been disseminated with anyone to this point in time. And there is, as I recall, a motion on the floor.
Motion and second, I think, wasn't it?
Yes.
Okay.
So I didn't get a chance. I was trying to deal with something in the agenda. I didn't get a chance to introduce myself again. But just for the record, I am Scott Husbands from Ginoli Husbands PLLC. I've been asked to appear here on behalf of both Jennifer and Ron as their counsel at this open personnel session. And I didn't get a chance to do that because Bruce just jumped in with this motion. And I think Councilman Durbridge and Mr. Sears have already made my points. I think what you're doing, I think, is problematic from an open meeting perspective. I think it's certainly problematic from the perspective of the Constitution.
I got responses to allegations. I don't know what the allegations are. I think if I'm going to respond to an allegation, I should know what it is. So I've made the motion. It's been seconded.
Okay, and the investigation that you're seeking, I think what you asked to do was place Ms. Rogan on leave with pay pending investigation.
That's what I did.
What's happening here today is the investigation. Councilman Hanson and Councilman Durbridge were bringing up the situation, I think it was with one of my former clients, Jim Allworth. And I know that the council at that point was very careful when Mr. Briggs was the city attorney not to get into any of the professional character, misconduct, competence issues, because the second you do that, they hadn't given notice. Here, notice was provided. My clients are here. We've prepared for it. They submitted their written responses. As far as I understand, there may be some documents the city is going to put forward. We have our own. As far as pending investigation, I think that's what we're here to do today, is to do that investigation to figure out exactly what the nature of these charges is, whether you can even do what you're doing in the context of these agenda items, I guess is a question for Mr. Sears, since all it does say is that discussion for possible action, but not limited to reprimand, demotion, promotion, endorsement, engagement, retention, or no action. In there is no mention of placement on leave, I don't think, or anything like that. So, I see that you guys have a number of issues here, and I think that we should just let them respond to the charges that have been advanced by Councilman Hanson and go forward from there. So I think it's again, as their attorney, I find it to be a very problematic motion that sits on the table at this point. But it is what it is. It's a motion that's been made, it's been seconded, so.
It's like I said, I think you hit the nail on the head. You have two operative verbs in there. First of all, discussion for possible action. And secondly, you've got consideration. There's absolutely no predetermined outcome of what we're doing, in part because we don't have that mechanism, and this agenda item that Randy's put on there would hopefully address that. I believe that's part of what it's doing. If we had come in with a predetermined notion that we want to sack them, then what Councilman Durbridge has brought out and how that proceeded last summer would have been what was on the agenda, merely to review it under the statute of are they continuing to serve that budget. So the fact that we proceeded in this direction leaves all those options open and on the table. So I think it's important that it's understood.
I guess, and my point would be, the proposal and the motion is to put her on leave. She's now being put on leave without any kind of...
She's on, I made the motion to put her on non-disciplinary administrative leave with pay.
Okay.
I
don't even know what
I
that
have in my hand responses to an allegation with my name in it, and I don't know what the allegations are. They've hired an attorney. Since my name is in here, I would like to consult my own attorney before I talk.
That's fine, I guess, but in that case, why subject her to some kind of discipline, which you're saying
It's not discipline.
It is
It's
disciplinary. It's
non-disciplinary.
disciplinary because it's going to go into a personnel file, whether you say it's non-disciplinary or it's not disciplinary. The issue is from a due process perspective. My client's, Jennifer, in this instance, says she received notice and she needs to have an opportunity to be heard. What you're doing to her is just taking that opportunity to be heard and dispensing with it by making a motion to put her on leave without,
What I'm doing is giving myself the opportunity to consult with an attorney because I had no idea I was going to be used as a witness.
What may be an appropriate procedure, given the fact that we do have a lot of evidence probably going to come in, and you're all going to have to make decisions on, is to continue these two so that everybody can take a look at the evidence. But there needs to be some rules. Okay? If you decide to continue this to another day, what you have to swear to do is not discuss any of the evidence with anybody else. So you can't call another councilman and talk to them. You can't call either one of these two and talk to them. You can't call me or him and talk to them. You have to consider it on your own, and you'll be put under oath that that's what you're going to do. You will consider all the evidence that's been presented with respect to this file today. You won't discuss it with anybody else. You won't read about it in the newspaper. You will just read it, understand it. If you want to seek legal counsel, you can certainly do that. But you can't talk to them. You can't talk to him. You can't talk to me. You can't talk to anybody. You can't talk to anybody in the audience. You just have to read it and consider it. That would be the procedure that we would normally follow with a jury, which is sort of what you are. You're a judge and jury. And that's what we make them do it.
I did not come here today to be a judge.
I know.
And I just saw the written responses to allegations that I've received.
I understand. That's why I'm suggesting it continue.
Yeah, this is not appropriate.
Well, I think that
You got a motion on the floor.
there is a motion on the floor. I kind of think the best way to do it is to do what the council suggested. I'm not your lawyer. I can't tell you what to do. But why not just continue it until everybody has had a chance to put those things in? I will say there seems to be an issue with getting some things before the council on a timely basis. I put those in today. I wasn't really told that they needed to be in until I think Tuesday. I had my clients work on them with me. I was stuck in a trial this morning from 9 until 2:30 or so. Didn't have a chance to get them out. So I do apologize for the late delivery on those things. But if it's
By themselves, they are they're nothing. I need to see the allegations.
right. Well, and I didn't. Yeah. If you don't have the allegations, then I guess how can you determine?
Exactly.
Well, then we
Yeah.
can take a vote and then do it.
Yes, we'll see if you got a motion in a second.
All right.
See where that one
Got a
goes.
motion for a first and a second. All in favor?
Aye.
Opposed?
I
Who opposed?
That failed.
Both of them?
You get three of those, didn't you?
yes.
So that one fails. Okay.
Now, the question is, does the rest of the city council receive a copy of the letters which they received, so they have that in front of them?
Sure. Okay. But I think now you need to talk about how you want to do that. You want to continue this? Give everybody a chance to read the letter.
I think we can even set some. We just did one of these just 2 weeks or so ago with the Department of Motor Vehicles. That's under the APA. Follows strict procedural guidelines with pre-hearing statements that have to be filed. You have to annex your exhibits and the whole 9 yards. It's informal. to the extent that you can have hearsay and you can lead people and do things you can't do in a trial court. But maybe if what Mr. Sears is suggesting, and I can talk to my clients, but I don't think they have any reason to disagree, is that we do something like that. I mean, I guess we already have the charges basically that Mr. Hansen has prepared. We have the written responses.
Wait, stop.
We have the response.
Well, what I'm saying is those have already been prepared, so those would constitute some of the documents that would be before the body anyway.
Let's start over. Who has these?
I do.
You do? Who else?
I'm the one who wrote them.
I have
Okay.
them. They were
You do.
delivered to my clients, yes.
The clients have, of course. They have.
That's how
I
they
do not.
No.
No, you don't.
Do
I
you,
was able to do it.
No, I don't have them.
Dale? Randy? And you expect us to take these up today and deal with them?
All I'm expecting you to do is just act consistent with the law, so whatever you want to do is fine. If you have a
The
concern about...
attorney suggests we continue this item?
You continue it, you all agree, you all take the same oath.
Well, that is why I voted against it, because I would think it's quite correct that you ought to have access to these documents exactly the way they're written, and a continuance will give you time to review that independently. Obviously, we're not going to talk to each other about these. We each arrive at our own conclusion independently, so that when we come back, we can have the entire thing before us, because you're exactly right. We've got the responses here. I'm the only one sitting at this table who has had the full schematic of the things, besides the attorney who reviewed those with me, of what is going on here. So I think a continuance would be the appropriate thing to do.
What time frame would be appropriate?
I mean, like I said, the charges have already been
To the next meeting?
written. We
You
can
want to go a
do it.
week, or you want to go to the next meeting?
I don't think I don't know something I can confer with my clients and see what they want to do. There's more time we need to put into this. I think maybe now would be the time, rather than coming back and saying, oh, but now there are additional documents and it's too late and whatever. Yeah, if I can just take a few minutes and talk to my clients and then we'll come back.
I guess we got, yeah, what you call it?
Recess. I'll recess this meeting.
I need to take 9.5 inches out of my driveway. I don't know what they call it, shaper. Do you have a shaper?
I don't feel sorry for you because you have it right.
Jordan said you had it.
Did you need somebody or you just here?
He said he will. He said he will.
No, the moderator ran my No, that's the other. That was on the transmission.
How come you didn't do it behind the flower? What's that? You can't even see the flowers. Black and white.
I don't get pictures of pictures. I thought it was going to be in color. I was disappointed when I found out it wasn't. I couldn't find the line on the front page. No, I just saw the paper today. I didn't know it was going to be like that. So. Sorry.
What page are we on?
It's the article starts to speak.
Oh, okay.
About them doing the planters and the benches downtown.
Did you make it as a big?
I did not.
It's a good
I'm
picture
sorry.
of the neighborhood.
I told Melanie, she called me.
Oh, we got somebody else. Nice boat bench.
So, starting next
I think we
Where are we at? He's mad. She'll be back. I'll call this meeting back to order.
So I've had a chance to talk to my clients. I think they're certainly fine with doing some kind of a, I guess it's a continuance really is what we refer to it as, but setting it out a week or two to give the council a chance to take a look at the document that Mr. Hanson prepared and to take a look at the written responses. Maybe we can, once the council decides that's what it wants to do, we can, Rich and I, right now, can set up some kind of timeline or parameters on what gets exchanged and when. So I think they have no objection to it.
The next council meeting, I move we move 12 and 15 to the next city council.
Second.
All in favor?
Aye.
No.
And I guess here would be my proposal then, Mr. Sears, the process we're looking at, is that 2 weeks from today, right? Maybe a week from today, a week before the next council meeting, we exchange any exhibits or...
Close the business next Thursday.
Yeah, close the business on Thursday, we'll exchange whatever exhibits, maybe a witness list or something like that.
Okay.
And then we can go from there. And I guess, I just would remind the council of Mr. Sears' admonishment in the meantime that nobody talked about this and that certainly nobody talked. You guys are welcome to talk to my clients about things that aren't related to this, of course, that are consistent with their job duties and fall within that. But if you're going to try and talk about anything that's covered by Mr. Hanson's charges and their written responses, then Mr. Sears and I would need to be involved in those conversations. So, that's how I see it.
And you can't discuss it with each other.
Right. Can't discuss it.
I can discuss it with one other councilman?
No.
Not at all?
No, discuss it with your lawyer. So you cannot, you're admonished, you cannot speak to each other about it, otherwise you quite frankly can taint the process. Nobody wants the process tainted. We're all looking for a fair process.
We can speak with outside counsel.
Yes.
Thank you.
Okay. Now go on to.
What's the violation by speaking to one of the councils?
You're deliberating outside of an open meeting.
Even just with one?
Absolutely.
I mean, is it the same as the open meeting law or
Yeah.
something different?
No, you can't deliberate, especially on something like this.
No, I'm talking about one other council. I know 3 you can.
No, you can't deliberate with another council on anything.
You have to be like a juror.
You're like a juror.
Oh, okay. All right.
No Facebook, no texting,
No
no
Facebook,
social
no
media.
texting.
We should bring Judge DeBrusky in here.
You're good.
All right.
Get all your information, yeah, that's right. I expect to see all the black robes and pearls next week. Maybe no pearls, but at least
Not
black
next
robes.
meeting, not next meeting.
Yeah, that's true. Would you accept a boa? Yeah, boa. That would work.
And that was as to both of my clients, right? Both Jennifer and Ron?
Yeah.
Okay. All right.
Well, wait a minute. That was only on Jennifer.
Oh,
That's
no.
the motion. You
The
added them
motion
together?
was 12 and 13. Were you correct?
Yes,
Jennifer?
yes.
You understand?
No. She only read 12. I never heard her read 13.
She didn't, but my motion was for both
12 and
12 and 13.
Okay.
All right.
All right.
Thank you. All right, we'll go back to. Okay. Okay, I'm going to adjourn this meeting for a meeting of the White Pine Historical Railroad Foundation Board of Trustees.
We'll open this meeting of the White Pine Historical Railroad Foundation Board of Trustees. Executive report. Mark Bassett couldn't be here, so we don't have a report.
Oh, you don't have a report?
So,
I think it's in the packet. So I had talked with him on the phone.
oh,
He had
there
said-
was, excuse me. Are there any questions on the executive report? Dan?
I get this thing thoroughly, and I'm already put forward this proposal here. Well, it's the report, I'm sorry. Yeah, this is a report, not much, never mind.
Anybody have any report? Marty? Okay, we'll move on to new business. Trustee Westland, discussion for possible action, review and implementation of procedure to place the Club 50 Railroad Crossing into exempt status pursuant to NRS 484B-560. Any discussion on this? Sam? Now,
I thought I thought we already directed Mark Bassett to do that.
We did.
And he came back with this particular report that the Nevada Department of Transportation strongly opposes this for a variety of reasons, which they you got from there and put them forward. And would suggest instead as a remedy that, and I thought the most significant one was, besides putting the much larger reflective warning labels on the back ends of the vehicles which would be affected, that there also be a pull-out lane on each side, because he points out some very significant things. When we start running rail traffic on that again, particularly freight traffic, it is very difficult to see as you're headed northbound a train coming also northbound, because it's almost on a parallel angle. It is such a sharp angle. And moreover, as you so well know, it takes quite a lot of time for a train to stop, half a mile to a quarter mile to a half a mile. He brings up some, what appears to be to me, some fairly valid points why you wouldn't want to do that. But I'm certainly looking to listen
This
to.
wasn't NDOT though.
It wasn't NDOT?
This is Rail Safety of
Oh, Rail Safety.
Nevada Public Utilities Commission.
Sorry, I confused it with NDOT.
Who I think, so I talked with Mark about this, and I'll do my best to answer whatever questions you have, but my understanding that Vic Crumley is the guy who's in charge of rail safety for the PUC, so this kind of thing would probably, if it was a request that the PUC exempt this crossing, my understanding is that Vic Crumley is the one who would probably, from the PUC, say it's not the PUC's position or opinion that they should exempt that crossing.
He's the authority from the state.
That's right. And the reasons why he would suggest not doing that, I think, are adequately explained in Mr. Bassett's letter. So,
May I speak?
Oh, I guess I'll let you.
We've heard this for years. Okay? I know Vic personally. I understand the PUC. I understand the DOT. Okay? I understand the reason for exemptions. Let me carefully outline the reason for an exemption. It's very simple. The reason to exempt a crossing is because it is safer to allow the traffic to continue through the crossing than to make them stop. We have visible evidence. If I sound passionate about this, it's because we have numerous examples of near misses at that crossing. Go out and take a picture of the skid marks. Okay? That's because something stopped and a number of vehicles behind them couldn't stop. All right? What we asked for was to have Mr. Bassett apply to the PUC, who has the authority to grant an exemption. We have a report from the Nevada Department of Transportation that suggests that this is what be done. They have offered their assistance to facilitate the public hearing that would make this crossing exempt. I would suggest that we will get that track open someday. I would also suggest that economics will dictate probably no more than one train a week will use it. I think this is a prime candidate, and we can argue about whether this is a spur or not. I think this is probably a 130-mile long spur. Okay? This is a dead-end railroad. It's not a transcontinental main line. Okay? And it has crossing gates. A very important fact. The crossing gates need to be kept operational. Okay? That's what prevents someone from running out onto the track when the train is coming. When you have a crossing out in the middle of nowhere, then it makes perfect sense. No protection at all. Make the bus stop and look both ways to see if the train is coming. When you have crossing gates with flashing lights and arms that come down once a week, twice maybe, one in, one out, you stop for that. Okay. The rest of the time you exempt the crossing. You allow the school bus to pass through so that he's not in danger of being rear-ended by the semi-driver that's asleep behind him. I've seen it myself. We had a very serious accident that killed a number of people in Montana. because of just such a situation. And we have evidence on the road, we have the testimony of truck drivers, we have the testimony of school bus drivers. This is a crossing that should be exempted. This should be put before the PUC and let them decide whether it should be exempted or not. This is not for us to do. This is to be put in front of the PUC and let the DOT testify about it. We own the railroad. We would be named in this suit. It's a liability issue. It's a safety issue. And I think that we are only prudent to ask the PUC. Now, if Vic Crumley wants to make a decision, I'm not sure that he is the PUC. He's a member of the PUC.
No, he's not the PUC. And I think this letter, just to put it in context too, and the mayor can correct me if I'm wrong, but I think the mayor had asked Mark to follow up with Vic or PUC. Is that right?
Yes.
Okay. I just wanted to make sure. So Mark by any means isn't trying to say we're not doing this. This is what it is. I think this letter was simply prepared at the request of, in some way, shape, or form, related to a request made by the mayor. So that's what he was bringing back to the council today. And I didn't talk to Vic, so I can't.
The problem I see too is twofold. One, maybe more than twofold. It's a safety to the buses. And the second thing is they're making track improvements. There's number one, and may be open by this fall. Second is they applied for a Tiger grant. We don't know if either one of those are going to come to fruition. And we would be remiss if right now, if we don't move to make that crossing safer now. And if something changes in the future, it's within our right to change our minds and do something different. But right now, to me, the only safe thing is to proceed and make that exempt. And I think we voted the last time, didn't we?
We did, and that's why I'm so passionate about this right now.
I think we should make sure it's done in the next week.
And Mr. Bassett never did make those phone calls, because I followed up on him. And he never did make the phone call. And we kind of went back and forth, and it was ended up through an email that he asked about it.
He never asked for the
No,
phone?
he never did. In fact, he said...
I think then we should have Jennifer Lee make a request to them to make that crossing exempt, since he failed to do what the Board of Trustees asked at the last meeting.
Do you want to make that motion?
I can't. I should.
Oh, I would make that motion.
I will second it.
All those in favor?
Aye.
Carried. If there's nothing else, we'll turn it back to the mayor.
The Ely City Council meeting is called back to order. Okay. Number 5, these are the items for discussion, possible action of the Ely City Council as recommended by the White Pine Historical Railroad Foundation Board of Trustees. And this is a discussion for possible action, review, and implementation of procedure to place the Club 50 Railroad Crossing into exempt status pursuant to NRS 484B. .560. Can I have a motion?
It'd make a motion that we direct the administration to contact them to continue our request to have it turned into some status crossing.
Second.
All in favor?
Aye.
Opposed? Okay. Number 6, consent agenda. Does anybody have any items to remove off of the minutes?
I got a question.
On the minutes of the bill.
On the bills. To Linnell Electric for $240. Can you tell me what that was for?
We believe that's streetlights.
Replacing light bulbs for the streetlights?
No.
It's for, I think, work at the wastewater.
I don't mean to argue with you, but I did look at the bill, and it was for lights. But yes, it was for street lights, and I wanted to make sure the rest of the council knew what it was for. Yes, it was for $240. My question was, last week, last council meeting, you had one for $1,225. $27.25, and I asked you if that's for streetlights, and your answer was no.
My answer was, if
Not
you go
those.
back, no.
you- all
I
right.
said, I have to look at the bill
Okay.
first. But I think it was for this.
All right, that's fine. My question was, both those $240 bills were from one day apart. One was for the 3rd and one was for the 4th. Why are they on separate bills?
Because when,
The dates on the invoices was April 3rd and April 4th for $240.
probably because when we receive the invoices, as they come in once a week, we enter them in the system. They do not post on anything until the checks are cut. Then when the checks are cut, then they're posted on the ledger. So probably either one was on the 3rd and one was on the 3rd, depending on when the mail system goes out and when we receive it is the question, when they actually sent them out. It could be dated the 3rd or the 4th, but it could be 1 or 2 days where it can go out. I mean, a lot of people's done it.
Okay.
But that's where a lot of people are there, even though we have to, in our system, in our Casell system, we have
That's
to
fine.
put
I
the
just wanted to make
invoice
sure
date on there.
that the rest of the council knew that both of those bills were for lights, changing light bulbs. That was all I was after.
And which lights we do three, when we receive 3 lights, like request that 3 lights are out, then we turn it over to them. Well, actually, we turn it over to Craigcraft, and then Craigcraft deals with it. That's what we do.
It's about a bill.
Move for approval.
Second.
All in favor?
Aye.
Opposed? Okay. This is old business. This is a discussion for possible action, approval of Mayor Van Camp's reappointment of Lyle Norcross to the Municipal Utility Board. Mr. Norcross's term expired July 1st, 2013. Therefore, his new term would end July 1st, 2017.
Move to approve your appointment.
Second.
All in favor?
Aye.
Opposed? Okay.
I abstain.
Okay, new business. This is a discussion for possible action. This is a consideration of incentive programs to bring new businesses to Ely, including charges for business licenses, landfill, water, sewer, and home occupation permits. Discussion would also include charges of out-of-county businesses which do business in Ely for a few jobs and then go back to their own county.
There's a number of companies that come into town. If you look at your business licenses, even in this, that came out this month, a list of business licenses. Robert Taylor for concrete construction, Genesee Hot Wire Electric. They come into town, they do a job, and they don't pay any landfill. Our own companies, contractors that live in town, pay a landfill fee. So I wanted to attach, when anybody gets a business license, if it's for construction and it's from somebody out of county, that they also be charged a landfill fee. Core Construction has been here over a year, but they don't pay a landfill fee. They're building the pool, they worked at charter of schools. They haven't paid any landfill fees. It's more costly for the contractors on our own county to do business than it is out of the county contractors, and I don't think that's fair. I think that if we're going to charge contractors a landfill fee, we need to charge all of them a landfill fee.
One thing I noticed in looking at those fees, there's a wide discrepancy, and I don't know what the formula is to determine what those fees are. For instance, I think the one you referenced is in the $300 range.
No. Are you?
I'm probably looking at the wrong document then, but it's The document I was looking at that had license fees on it there.
Most of the landfill fees for contractors,
No, I'm talking about the business license fee. It was all over the place, and I was just wondering if that was already pre-included in the cost of the business license.
no,
Any
because
anticipation?
if you take Metalscape Incorporated, doing ironworks,
No.
their business license is for a full year.
Not that one. Not that one.
All of these business licenses are for full years.
I'm looking at the April, not even April, which one was it I was looking at earlier?
Where's your computer, Sam?
Are you talking about the top one, 295.73?
Might be that one. It just seemed like there were a whole bunch of things that were just all over the place in terms of the schedule of how much we're charging businesses to get a license.
I think it goes back to what the utility board was looking at landfill fees, because some contractors, when they do a job, it's the owner or the homeowner or the business pays the landfill fees when they take things to the dump, not actually the contract.
No. No, no, no.
Ron?
When in Rome.
I wish I looked at my dump at the stuff.
How does say a contractor's working on my house and he takes junk from my house to the landfill? Is it charged to me or to the contractor?
It's charged to the contractor. Yeah, Linda's here.
Can you answer that?
Yes, I can. Subsequently, it is charged to the contractor, then it is back charged to the customer. And Core Construction has been charged for construction. They use the dumpster for EV disposal, and we charge EV disposal, and EV disposal charges them.
I used Core Construction as an example.
But they are being charged.
Okay, then where I didn't want to go, the ones you catch, what about the contractor that doesn't have a name on his truck? How do you know to charge him or not?
I inquire. I mean, I quiz him. I myself always find them. I don't know about the rest of the guys, I can only speak for myself.
Okay, I know that a lot of contractors,
There's some, yes, I have to agree, that do go by, but I'm not there all the time.
right, I know you told me that you catch everyone, but the other people, they get by.
Well, I'm
So
not
if we
saying the
attach
other
a
people, I'm just
landfill fee to
saying,
their
I'm-
business license, like we do, Bruce Hunt Electric pays $48.99 a month for landfill. Then he also pays when he comes to the landfill, correct?
come again, tell me again.
I'm using a general contractor. When they come to the landfill, you charge them $7.95 a ton or whatever it is you charge them, correct? Commercial waste is charged by the ton.
And that depends on whether they have a city license or not. If they don't have the city license, they get charged a higher rate.
Right. Bruce Hunt pays $48.99 a month, plus what he brings to the landfill.
Bruce never has brought any construction that I know. Oh, this is just an example.
I'm using Bruce as an example. A contractor, any contractor,
I'm following you now.
any contractor,
Uh-huh.
when they pull up to your gate, you charge them for how many yards they bring in, correct?
Correct.
Okay, so whatever they use, you charge them for.
Exactly.
Those contractors also pay a monthly fee of $48.99 a month. That's not a question for you. That's a fact.
That is,
Okay.
because
The
charge,
businesses,
the fee is for like shop cleanup and stuff like that. That's why they're at a higher rate. Probably Dale Derby